Have you ever wondered what legal requirements you need to meet to make a valid will in the Philippines? Ensuring that your last will and testament is legally binding is crucial to prevent potential disputes and ensure that your final wishes are respected after your passing. Testamentary capacity, or the legal ability to make a valid will, is one of the frequently asked topics in the Philippine Bar Examination. Understanding the requirements for testamentary capacity is essential for bar examinees, law students, and legal professionals alike. This video will provide you with a comprehensive overview of the legal provisions governing testamentary capacity under the Civil Code of the Philippines. Articles 796 to 803. By watching this content, bar examinees will gain valuable insights into a crucial aspect of succession law, better preparing them for the bar exam. Law students will deepen their understanding of testamentary capacity, a fundamental concept in wills and estates. Legal professionals, such as lawyers and notaries, will refresh their knowledge, ensuring they can provide sound advice to clients regarding the execution of valid wills. Don't forget to subscribe to our channel to stay updated with more informative legal content.
Testamentary capacity, or the legal ability to make a valid will, is governed by Articles 796 to 803 of the Civil Code of the Philippines. These provisions outline the specific requirements an individual must meet to be considered legally capable of executing a will. Article 796 states that no will, except a holographic will, shall be valid unless it is ratified by the testator after the removal of the vice of consent, or after the recovery of his/her disposing mind. This article establishes the fundamental principle that, for a will to be valid, the testator, the person making the will, must have the necessary mental capacity and be free from any vices of consent, such as fraud, violence, intimidation, or undue influence. Article 797 further clarifies the mental capacity requirement, stating that to be capable of making a will, it is essential that the testator be of sound mind at the time of its execution. This article underscores the importance of the testator being of sound mind, which generally means that they must have the mental capacity to understand the nature and consequences of their actions, as well as the ability to comprehend the extent and distribution of their properties. Article 798 provides additional guidance on determining soundness of mind, stating that in order to judge the capacity of the testator, his/her state and behavior at the time the will was executed shall be the main criterion. This article emphasizes that the testator's mental state and behavior at the precise moment of executing the will are the primary factors in assessing their testamentary capacity.
Article 799 addresses temporary incapacity, stating that the will of a person who, by reason of insanity or imbecility, is not wholly devoid of the requisite intelligence, shall be respected with regard to the formalities of the execution thereof, whenever said person has had a lucid interval. This provision recognizes that individuals with mental disabilities or conditions may experience periods of lucidity, during which they may possess the necessary capacity to execute a valid will. Article 800 deals with the presumption of sanity, stating that, in the absence of proof showing the contrary, every person is presumed to be of sound mind. This article establishes a legal presumption that individuals are presumed to have the necessary mental capacity unless proven otherwise. Article 801 addresses the burden of proof in cases where testamentary capacity is challenged, stating that the burden of proof that the testator was not of sound mind at the time of making his dispositions lies on the person who opposes the validity of the will. This provision places the burden of proving lack of testamentary capacity on the party challenging the validity of the will, rather than requiring the proponent of the will to prove the testator's soundness of mind. Article 802 provides guidance on the weight of expert testimony in determining testamentary capacity, stating that the testimony of the attesting witnesses and the opinions of qualified physicians as to the mental condition of the testator at the time of the execution of the will shall be admissible as expert evidence. This article recognizes the importance of expert testimony, such as from attesting witnesses and qualified medical professionals, in assessing the testator's mental state and capacity at the time of executing the will.
Article 803 addresses the impact of subsequent incapacity on the validity of the will, stating that the subsequent insanity or imbecility of the testator shall not be a ground for revoking his will, which shall be respected whenever it may have been validly executed. This provision ensures that a validly executed will remains valid even if the testator subsequently develops a mental incapacity or condition that would render them incapable of making a new will. Subscribe to our channel to stay updated with more informative legal content on various aspects of Philippine law.
Frequently asked questions. 1. Can a person under the influence of drugs or alcohol make a valid will? Answer: no. A person under the influence of drugs or alcohol would likely be considered to lack the necessary testamentary capacity due to impaired mental faculties. Article 796 requires the testator to be free from any vices of consent, which would include the influence of substances that impair judgment and decision-making ability. 2. Can a minor make a valid will? Answer: no. Minors, individuals under the age of 18 in the Philippines, are presumed to lack the necessary mental capacity to make a valid will. Article 797 requires the testator to be of sound mind, which generally implies legal adulthood. 3. What happens if a person's mental capacity fluctuates during the execution of the will? Answer: according to Article 798, the testator's state and behavior at the precise time of executing the will are the primary criteria for determining testamentary capacity. If the testator experienced a lucid interval during the execution and met the capacity requirements at that moment, the will may still be considered valid, as per Article 799.
Philippine Bar Exam questions. Question number 1. Clara, thinking of her mortality, drafted a will and asked Roberta, Hannah, Louisa, and Benjamin to be witnesses. During the day of signing of her will, Clara fell down the stairs and broke her arms. Coming from the hospital, Clara insisted on signing her will by thumb mark and said that she can sign her full name later. While the will was being signed, Roberta experienced a stomachache and kept going to the restroom for long periods of time. Hannah, while waiting for her turn to sign the will, was reading the 7th Harry Potter book on the couch, beside the table on which everyone was signing. Benjamin, aside from witnessing the will, also offered to notarize it. A week after, Clara was run over by a drunk driver while crossing the street in Greenbelt. May the will of Clara be admitted to probate? Give your reasons briefly. 2007, 1994 Bar. Answer: no, the probate should be denied. The requirement that the testator and at least 3 witnesses must sign all in the presence of one another was not complied with. Benjamin, who notarized the will, is disqualified as a witness, hence he cannot be counted as one of the 3 witnesses. Cruz vs. Villazer, Gr. No. L32213, November 26, 1973, the testatrix and the other witnesses signed the will not in the presence of Roberta because she was in the restroom for extended periods of time. Inside the restroom, Roberta could not have possibly seen the testatrix and the other witnesses signed the will by merely casting her eyes in the proper direction. Jabanita vs. Gustello, Gr. number 1641, January 19, 1906, Nara vs. Ramondo, Gr. No. L5971, February 27, 1911.
Therefore, the testatrix signed the will in the presence of only 2 witnesses, and only 2 witnesses signed the will in the presence of the testatrix and of one another. It is to be noted, however, that the thumb mark intended by the testator to be his signature in executing his last will and testament is valid. Pied vs. Tolentino, Gr. number 42258, September 5, 1936, Matias vs. Salud, Gr. No. L10751, June 23, 1958. The problem, however, states that Clara said that she can sign her full name later, hence, she did not consider her thumb mark as her complete signature, and intended further action on her part. The testatrix and the other witness signed the will in the presence of Hannah. Because she was aware of her function and role as witness and was in a position to see the testatrix and the other witnesses sign by merely casting her eyes in the proper direction. Question number 2. Question. Johnny, with no known living relatives, executed a notarial will giving all his estate to his sweetheart. One day, he had a serious altercation with his sweetheart. A few days later, he was introduced to a charming lady who later became a dear friend. Soon after, he executed a holographic will expressly revoking the notarial will and so designating his new friend as sole heir. One day when he was clearing up his desk, Johnny mistakenly burned, along with other papers, the only copy of his holographic will. His business associate, Eduardo, knew well the contents of the will, which was shown to him by Johnny the day it was executed. A few days after the burning incident, Johnny died. Both wills were sought to be probated in 2 separate petitions. Will either or both petitions prosper? 1997 Bar.
Answer: the probate of the notarial will shall prosper. The holographic will cannot be admitted to probate because a holographic will can only be probated upon evidence of the will itself unless there is a photographic copy. But since the holographic will was lost and there was no other copy, it cannot be probated. Therefore, the notarial will shall be admitted to probate because there is no revoking will. In the case of Gone vs. Yap, Gr. No. L12190, August 30, 1958, the execution and the contents of a lost or destroyed holographic will may not be proved by the bare testimony of witnesses who have seen or read such will. The will itself must be presented, otherwise it shall produce no effect. The law regards the document itself as material proof of authenticity.